I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
I would suggest you apply for a lawyer instead of just complain.
All right, guys. Today we've got one of the dumbest sovereign citizens I've ever seen. How are we still dealing with this nonsense in 2025? This man can barely read, yet somehow thinks he's got the legal chops to defend himself in court. His argument? He claims the trial isn't fair because he only had 1 hour to study the law, while the prosecutor had 7 years in law school. I'm not kidding. That's like showing up to a marathon in flip-flops, then whining that the Olympic runners trained too hard. It's gonna be painful. But trust me, it's pure comedy. Drop your thoughts in the comments and let's watch this train wreck unfold.
ST 226707ST and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and you're proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or inadequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct.
This man can barely read, yet he's standing up in court trying to read legal motions like he's Thurgood Marshall. Be real. What would you rate his reading level? I'm saying 6th grade, and that's being generous. But here's the kicker. He's mad that he didn't have enough time to study the law. Like the judge is just gonna pause the whole court system for 6 years so he can go to law school, sir? No. The court already gave him options. Hire a lawyer, take a public defender, or represent yourself if you know what you're doing. Spoiler, he doesn't. What's next? Is he gonna ask for a delay so he can apply?
For every waste of time and the more money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court. And for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out. And when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on. And I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion. Prosecutors Rule 3.8, didn't take action or all actions, making sure my rights were protected, and rules.
To the Supreme Court? Let's keep watching. Is anyone else just waiting for the judge to say, "Nice speech, little guy, motion denied"? Because that's exactly where this is headed. This man read his motion like he was delivering the Gettysburg Address, and I swear, the judge probably let him ramble just for the entertainment. Judges can deny ridiculous motions on sight, especially when they waste the court's time. This, textbook nonsense. Rule 11 of the Federal Rules of Civil Procedure literally exists to stop stuff like this. Courts can sanction people for filing bogus motions. But this guy thinks if he talks long enough, the judge will
stating that I shouldn't be in jail or in prison for fines, when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws to that. If we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature, to the extent that he's setting himself up or trying to set himself up for these objections. I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like, there's no way that I
will magically see the light and toss the case. Spoiler alert, that's not happening. I can't figure out if this guy's playing dumb or if he's actually just this clueless. He's facing real jail time and he's out here winging it like it's a pop quiz. This ain't high school, bro. He had every chance to get a free court-appointed attorney, free. But instead he files nonsense, complains about not having time to study the law, and wastes everyone's time like the system owes him something. What did he think this was? An open book test? This is like that one kid in class who didn't do the research and just made stuff up during the presentation. Except now
Familiar with that. I've been at it about 35 years now.
okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that, and you didn't want that either. So then we went through the hearings, and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws stating and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything you
gave me
wish.
bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, and he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new trial along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez.
How the grade is jail time. Let me know. Do you think he's faking it? Or is this the real him? Honestly? The judge handled this perfectly. Personally, I would have cut him off way sooner, but hey, we got a good laugh out of it. This man really walked into court thinking he was going to finesse his way to victory, reading from a crumpled paper that looked like it came from the jail floor. This right here is exactly why it's important to actually know your rights, so you don't embarrass yourself trying to freestyle courtroom law like this guy did. The judge gave him every chance to get real help, and he still fumbled the bag. No court is going to take your motion seriously when you refuse free legal help and choose to play pretend lawyer instead. This might honestly be one of the worst legal arguments I've ever heard, but hey, at least it was entertaining. All right, I'm wrapping this one up. Let me know in the comments, was this guy a sovereign citizen or just someone who got way too confident with a jailhouse Google search? Also, be honest. What grade would you give his reading level? I said 6th grade before, but after that performance, 3rd grade might be generous. If you liked the video, hit that like and subscribe. I post courtroom chaos daily. Got a case you want me to cover? Drop it in the comments. Thanks for watching. Take care, everyone.